If the court blocks race as a consideration in redistricting, it would have sweeping consequences for the entire nation. Politico reports Republicans might be able to draw as many as 19 new House seats that favor the party. What's more, it would likely decimate minority representation in Congress. Joining us now, Janai Nelson, President and Director Counsel of the Director Counsel of the Legal Defense Fund. She is also the one who argued in defense of young voting rights today before the justices. Also with us, Rick Hasen, Professor of Law and Political Science at UCLA Law School.
I listened to all of the arguments today with great frustration and, frankly, with some great admiration for you, Janai. It felt like this is what it was like to hear people who witnessed Thurgood Marshall arguing before the Supreme Court back in his day before he was a justice. I want to play Justice Brett Kavanaugh and what he had to say about race-based remedies having an endpoint.
This court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint.
Okay. I heard a lot today, and I think for me it boiled down to I heard some of the conservative justices making the case for reverse racism. It's not a term that they used, but they used the term discrimination on the basis of race. They were essentially asking questions along the lines of, how is this not discrimination on the basis of race against non-black voters? They were saying this is white people are being discriminated against in Louisiana, so you all cannot have this district.
That is essentially what not the court was saying, but that is the argument from the plaintiffs in the case. And if you look at the reality on the ground, nothing could be further from the truth. 42% of black people in Louisiana live in majority white congressional districts. So the two districts that they have the ability to control the outcome of is nothing in comparison to the numbers. Black people in Louisiana are 1/3 of the state's electorate, and white people are approximately 58%. And under the original map, they controlled 83% of the congressional districts. Under the remedial map, they still controlled 66%. So if we look just on raw numbers alone, they are overrepresented. They have super proportionality, as we call it. And what the remedial map does that we've been defending is give black voters a fair shot, not even a fair share, just a fair shot at electing representatives of their choice.
Professor Hasen, you have been making the argument that this is bigger than Louisiana, that this actually could open the aperture on the Voting Rights Act. Tell me more.
Well, back in 2013, the court killed off one of the two pillars of the Voting Rights Act, Section 5, in the Shelby County case. And when they did that, they said, don't worry, there's Section 2, it applies nationally, and it protects minority voters. In the oral argument that I listened to today, it sounded like the conservative justices who make up a majority on the court were prepared either to hold Section 2 unconstitutional in certain applications or deprive it of its strength so that it would no longer require the creation of districts. This would have effects beyond Louisiana's congressional district. Not only would it apply to congressional districts around the country and perhaps lead to a round of redistricting in places where they could get rid of some of these minority opportunity districts. It also applies to state legislatures and to city councils. It could have effects up and down the country in just about every state where there is a sizable minority population. As Janai said, not to get proportional representation, but to just have a fair shot at being able to elect their candidates of choice.
I think, Janai, from my perspective, the Supreme Court, this is kind of pro forma today. The predicate has been laid. And I think Mr. Hasen just really kind of framed it because in the 2013 case, that was the first breaking, the first crack. Now we're here when they told us, oh, don't worry about Section 2. That's fine. That's national. You still have cover there. You'll still be able to draw the lines and da-da-da. And now here we are. So I'm not convinced that this court has already designed the outcome here, because it would otherwise be inconsistent in the direction they're going. The second part in listening to this, and particularly given that the Louisiana Solicitor General said that race played an outsized role in creating those majority black districts, was race an outside, play an outside role in creating the majority white districts around the country?
That's a great question. And I think anyone looking at the facts on a objective basis would ask that very question. The justices should be concerned about the gross imbalance of political power that exists in this country along the lines of race, not party, strictly race. Right. It's a real issue. But I will say this. Many people thought that a case that the Legal Defense Fund brought a couple of years ago, Allen versus Milligan, that was a nearly identical challenge. Everyone thought that that case was dead on arrival. But the Supreme Court followed its own precedent. They understood the egregious discrimination that was happening in the state of Alabama, and they issued an excellent decision written by Chief Justice Roberts that we believe controls the Louisiana case as well. Now, is it concerning that they asked for re-argument after we already argued this case in March? Absolutely. Right. But are they locked in, or should they be locked into their own words and their own precedent based on stare decisis, which is, the legal concept that you have to follow what the existing law is? Absolutely. And I hope they appreciated that even more today when they heard some of the absurdist arguments on the other side that go against 150 years of precedent.
I kept hearing a lot today during the oral arguments about the 14th, 15th Amendments, Equal Protection Clause. How does that fit into this conversation we're having? Because I think Rick is right, and you all have also made this case that it is bigger than just Louisiana. I think the district, literally, the case you're talking about, the Supreme Court ruled in, that was in 2023.
28 months ago.
28 months ago, where they upheld Section 2 of the Voting Rights Act. And to now come 28 months later and seem as though this is a different court, I was confused. But a lot about the 14th, 15th Amendments, these are the Reconstruction Amendments, the amendments that came about after the ending of literally one of the amendments, 13, abolished slavery. How does that play into this conversation we're having?
Yeah, well, the 15th Amendment is the only time that race is explicitly mentioned in the Constitution. We have a protection that has been what Chief Justice Roberts wrote in that Allen versus Milligan opinion, just a parchment promise for the first century of its existence. It's only through the passage of the Voting Rights Act in 1965 that we really began to robustly counter race discrimination in voting. So the idea that a mere 60 years later, which is in the lifetime of many of the clients that we represent, we have clients who are as young as 30 and as old as 88 who have seen the Voting Rights Act get passed and the work that it has done during their lifetimes. And the 15th Amendment is a permanent part of our Constitution. So it plays a central role in this case. What we see happening on the other side is an effort to manipulate the 14th Amendment, the Equal Protection Clause, and suggest that if you use race to remedy discrimination, somehow that's discriminating against other people. And that just makes no sense. Not only is it illogical just in everyday thinking, but the Supreme Court has been very clear that you can use race in a narrow, limited way to remedy specific discrimination. What's also really important to know about this part of the Voting Rights Act is that it doesn't require the use of race. There are at least, countless maps that you could use to bring the state into compliance with the Constitution and with Section 2 without having race predominate in a way that might concern the court. So there's no excuse for allowing the discrimination in Louisiana to remain unremedied. None at all. And that's why we've asked the court to remand the case so that they can adopt an appropriate map if they are not satisfied with this one.